So hello everyone, myself Advocate Gautam Harshwal, working at LEXIS and Company Law Firm as a junior associate. So today in this video I am going to discuss with you another legal topic as we always do. The name of the topic is bail in non-bailable offences. We all know that there are two types of offences in India. First is bailable offence and the another is non-bailable offence. So this is the question you might ask to any other person or might arise in your mind that can we get bail in bailable offense, non-bailable offences? Non-bailable offences are those offences which are serious in nature, right? So in this video I am going to try my best to cover all the all the queries related to this. Can you be granted bail in non-bailable offences? So without further any delay, let's start our discussion. So before starting our discussion, I can let me tell you that this is the first part. In the second part I am going to discuss the remaining part of bail in non-bailable offences, because it's a huge topic. It's not a it's a wide topic basically. It is not possible to cover it in the one video. So let us start our discussion. Basically, bail in non-bailable offences. In Indian criminal justice system, bail is the legal process by which a person accused of committing a crime is released from custody, subject to certain conditions. Pending trial, bail is discretionary, which means that judge has the power to decide whether or not to grant bail, bail based on the critical circumstances of the case. It's all about judge's decision to grant bail or not, right? In non-bailable offences, the right to bail is not automatic, and the accused must specifically apply for bail, right? The Supreme Court of India has laid down guidelines for granting bail in non-bailable offences. The Supreme Court of India has clearly wrote down the guidelines related to non-bailable offences, or in cases of non-bailable, which says that which lower courts have followed, right? However, the use of these guidelines has been criticized and controversial as well. We all know if there is law, there are people in favor of that law, and there are people also who criticize the law, right? So that's same goes in the in these guidelines. In the case of these guidelines, in this discussion I am going to examine, basically I am trying my best to examine the Supreme Court's guidance on bail in non-bailable offences and examine its application in practice, right? So guidelines for granting bail in non-bailable offences. The first is nature of the offence. The first guidelines says that the seriousness of the offence is the first and foremost consideration in determining whether to grant bail or not. The more serious the crime is, the less likely it is that bail will be granted. Evidence against the accused. If there is strong evidence against the accused, conviction is less likely to be granted. However, if the evidence is weak or circumstantial, the court may grant admission, right? The another is character and reputation of the accused. This is a very important thing you must keep in mind, that what is the reputation of that person in the society as a person, right? If someone is has a criminal record, he cannot be granted bail. But if someone is of is a civilized person or a government employee, or someone who is 9 to 6 person job, or a person has a good reputation in the society, also matters, right? The court, the judge takes him consideration other than other people, right? So why character and reputation of the accused? The past criminal record, character and reputation of the accused are also considered in determining whether to grant bail or not. If the accused has a history of good behavior and no criminal record, this may justify bail, right? Probability of absconding of the accused. If there is possibility of absconding of the accused, if released on bail, court is less likely to grant bail. The another is risk to witnesses of the or the public. If the release of the accused would pose a danger to witnesses or the public, the court is unlikely to grant bail. Court will not grant bail to such people. If they grant the bail, then he he can be he can be threat for the person or the witnesses, right? Length of the time the accused has already spent in prison. If the accused has already spent some time in prison, the court may grant bail in that, only in that case. Let's discuss the critical analysis on application of guidelines in practice. Notwithstanding the guidelines established by the Supreme Court for bail in irredeemable offences, how their application in practice has been challenged and controversial. Critics says that guidelines are often not followed in practice, and the discretion given to the judges leads to the fair and unequal treatment of the accused. So that's all about our discussion on bail in non-bailable cases, non-bailable offences. In the second part, don't forget to watch the second part. I am going to discuss the detail or the remaining part of this video. See you in the next video. Till then, bye bye. But before we go, do hit that like button, share this video with your friends. See you in the next video. Bye.